Good morning, afternoon to everyone again. Thanks for joining us. Really excited to have you here. Great topic today. This is the fourth, I believe, in our new-ish Labor Spotlight series, which is a series that focuses on more practical issues related to labor in the workplace across Canada, not just Ontario. And we've got today Eleni Kassaris and Victoria Merritt from our Vancouver office, and they're going to be speaking on managing multiple claims and investigations in unionized workplaces. Eleni is the group practice lead and a partner, obviously, in our Vancouver office, and Victoria is an associate in Eleni's group. I'll pass it off to them. Eleni?
Yes, thanks, Russ. If we can just go to the next slide. So I wanted to dive in and start talking about issues that we've been seeing more and more of in the last several years, especially during the pandemic in BC. So I will be using BC as a bit of a frame of reference, but generally speaking, we've been seeing more and more multiple claims from the unionized environment. So even though notionally any dispute arising out of employment should be arising under the collective agreement and should be properly handled via the grievance arbitration process, we have been seeing a lot of different scenarios where we get not only a grievance, but we might also get a human rights complaint in BC. And we might also get some kind of workers' comp claim or a privacy complaint under our privacy legislation. And it's become a bit of a juggling act. How do you juggle these different proceedings, and what are the laws relating to making sure that if there is a basis to say to one adjudicator, you can't hear this because we're dealing with it in another forum, that we should know those boundaries and be able to push against them. So generally speaking, certain decision makers have to have jurisdiction over their subject matter in order to be able to hear the matter. So for example, the jurisdiction of the arbitrator is granted via the collective agreement and the labor relations codes of the different provinces, and under the Canada Labor Code, of course, if you're federally regulated. And those specific issues have been held, for example, by the Supreme Court of Canada to include jurisdiction over human rights, provided the human rights issue arises under the collective agreement, which it usually does. So we do have, in the circumstance of the arbitrator, that exclusive jurisdiction right to determine issues. That being said, even though the arbitrator has exclusive jurisdiction over human rights matters, usually employment standards matters based on how the legislation is set up, and usually over most workplace matters, there are some exceptions and some concurrent jurisdictions that you have to be concerned about depending where your employees are and where your unionized workforces are. So we do have in BC concurrent jurisdiction, for example, on human rights. So it is quite common to have a situation where the grievance has been commenced by the union, but the employee has also commenced a human rights complaint. So when that has happened, we have to sort of decide, okay, what do we do here? And in all honesty, I think this is the case across the country, but the Human Rights Tribunal in BC is incredibly backlog. They're catching up, but it is the case that in BC, if you have a grievance, it can be fully determined and decided in less time than it will take the Human Rights Tribunal to actually serve the complaint on the employer. So it's a little bit of a crazy situation. In the normal course of things, if you were aware of the complaint and served with the complaint at the same time as the grievance was happening, you could seek from the tribunal a deferral of the proceeding. So can the proceeding be deferred, stayed, or suspended in favor of the grievance or in favor of some other proceeding that's occurring? And it's important to know the different tests in your jurisdictions about how to stay something. The factors that tribunals usually consider is whether the grievance is imminent. And as I said, it's highly likely that it's going to happen first in time. whether there's the remedies available in the other proceeding are adequate to address the human rights violations. So, with the arbitrator having full authority to remedy human rights violations, that should be a non-issue, so a deferral should occur. Whether there's a fairness issue or a prejudice issue with respect to deferring the human rights proceeding in favor of a different proceeding, those types of considerations. So for the most part, you shouldn't be running at the same time multiple proceedings. There should be an order to things, but you will have to face the issue of, we have these multiple proceedings, how do we deal with them? If we can go to the next slide. So a sort of typical scenario in BC is that an employee will raise a health and safety concern and is later sort of disciplined or fired for some unrelated purpose. So in this scenario, you've got a BC employee who raises a health and safety concern. He's suspended 1 week for 1 week at a later time after several verbal and written warnings relating to his lateness and absenteeism. He submits a prohibited action complaint, which is under our Workers' Compensation Act in British Columbia, and a human rights complaint saying but he says that he was actually terminated because he raised the safety issue, but also because he's late and misses work due to family reasons. So he asserts a family status complaint under human rights. And the union also grieves the suspension. So what now? Now, generally speaking, having mastery of the different pieces of legislation that might be in play here is very important. So it's very clear under the Workers' Compensation Act that an employee cannot have both a grievance and a prohibited action complaint. So they must make an election, which is interesting because it's not really the employee that would elect whether or not to grieve a matter. That would be the union who would elect whether or not to grieve a matter. But the language of our statute makes it clear that the employer, the worker, must make an election. So with that in mind, it is open to the employer to try to have the prohibited action complaint stayed or delayed or somehow deferred pending the outcome of the grievance. And the reason why you can't really have it dismissed in first instance is because the tribunals want to see that the arbitrator dealt with the subject matter of the complaint. And if the arbitrator deals with the subject matter of the complaint, you can then at a later stage seek to dismiss that complaint on the basis that it has already been adjudicated. And that is similar on the human rights side. So on the human rights side, like I said, in this scenario, if the employee were to choose, okay, I don't want this grievance, I've been suspended, I'm going to proceed with prohibited action. And we do sometimes see unions actually direct employees to bring prohibited action complaints instead of grievances because they think there's some strategic advantage to having WorkSafe BC or the Workers' Compensation Board in the applicable province make a determination on a particular issue. And they think there's some general advantage to the workforce beyond the discipline grievance. So if that has occurred, you have to consider, okay, well, do we try to settle this particular prohibited action complaint or particular workers' compensation matter? Or do we go all the way to a decision to make sure that the employer's position is preserved and whatever strategic element the union is trying to exploit or manipulate is not successful? So the prohibited action complaints, if it does proceed that way and not through a grievance, those two usually can be completed in BC, like fully completed and in the decision phase. We've got several in our office right now where we're waiting for written decisions and we've just received the human rights complaints. So in those circumstances, we're not necessarily applying to defer the human rights complaint, but we are hoping that that decision will come out soon and will allow us to use it to our advantage in the human rights matter. So the human rights matters, if it completely overlaps, which they often do not, we can leverage a favorable decision in a different forum to bring some resolution to the human rights matter. Now, the tricky part is you also have to have a mastery of your remedies. So the tribunal will be concerned, for example, if you're before a workers' compensation board, which is typically engaged in the analysis of lost wages and whether or not there's wage loss to be awarded, and don't typically award injury to dignity damages or any kind of non-taxable damages relating to, moral damages or aggravated damages. That is the realm of human rights and the courts and an arbitrator if it had gone to a grievance. So in that circumstance, you have to sort of see, how much can I really leverage this particular workers' compensation decision that's coming and we think is going to be favorable in order to resolve the tribunal matter, which you may or may not even have. You just are aware that it exists because the employee has told you that they've also filed a human rights matter. And one of the ways to do that is, of course, to consider global settlement. And I think this is what the employees and the unions are really after. They're wanting to throw a lot at the particular issue by multiple proceedings to try to create leverage for settlement. And that may be a good thing. That may be a good thing in most cases where you can try to have a reasonable low amount of money given to a union employee to settle a matter, provided you get a global settlement so that all proceedings are withdrawn. You don't have to, piecemeal settle. In fact, I don't remember a circumstance in my whole career, closing in on 22 years, where I would have recommended to a client to settle one action, but not settle a different proceeding when we know that there's more than one proceeding out there. In fact, we would make it a condition of any settlement to make sure that you withdraw all matters, even if we know about them or don't know about them. So it is important to think about, okay, how do I best leverage the fact that as an employer, it's out of our control that these multiple proceedings have been commenced. All we can do is work within the parameters set by legislation, which may include applying for a stay of one proceeding in favor of another, or deferring the proceeding pending the outcome of another. But how do we leverage what we can do in order to get a good outcome globally? And if that leads you down a settlement path that is reasonable and of low cost, that ultimately is of value, because at the end of the day, the cost of defending all of these multiple matters can be quite high. So with that, I just want to talk briefly on the next slide about certain other proceedings and considerations that we sometimes see. We do have some law about abeyance or stays of proceedings of labor matters in favor of criminal proceedings. And as you can imagine, if someone has criminal charges and is waiting for their day in court to determine whether or not they go to jail, they usually don't want to have their grievance heard where they have to give evidence about their misconduct, or others might be giving evidence about their misconduct because it could be prejudicial. The flip side of that, and we have seen some case law, is where the grievance is, unduly delayed, because the criminal law process, of course, can take years. So we have one major case from recent history where the griever was trying to further delay the hearing pending an appeal of his conviction. And the employer fought against that and said it's prejudicial. A lot of time has passed, a lot of witnesses, their memories are fading. We need to just do this grievance. And the court ultimately said, no, you have to wait pending the appeal, because it could impact findings of fact, and it would be unduly prejudicial to the employee to have to proceed with the grievance while they're waiting for the outcome of their appeal. So at the same time, ultimately, there will be a balancing of prejudice and who is more disadvantaged by a stay versus an order making the matter proceed. And usually on the criminal side, you will have a situation where the prejudice, if the prejudice is pronounced or reasonable, there's reasonable prejudice for the griever, that all your proceedings will be stayed and you'll just kind of be stuck waiting as the employer. An interesting, things that are outside of the scope of the collective agreement are often brought through a different forum. They wouldn't be brought through the grievance procedure. And that would include claims like defamation made by parties in the workplace. It wouldn't necessarily be relating to the workplace. But that being said, if you can tie the defamation back to the collective agreement, then you can take advantage of your grievance procedure. And we saw that in a case, like a wonderful case, a case called Civio Corporation and Unite Here Local 40, where the employer brought a grievance against the union for defamation in the context of certain lies and other, misconduct by the union in the course of the unionized relationship. And the arbitrator not only found that he had jurisdiction to determine the issue because it all arose from the collective agreement, but also that the union should pay the employer $400,000 in general damages for the defamation. So it was a really interesting case. The union asserted that this should be a civil claim, this should be through the courts, and the arbitrator rejected that and formulated an argument, I think of his own accord to some degree, if you read the case, that he had the jurisdiction to hear the defamation claim, and it wasn't solely something that would be within the civil courts. So it was an interesting case. So you always have to think about what is the best push for the case. Should we be pushing for a grievance? Should we be pushing this to court? Is it possible to push to court? Because there's a bright line in terms of a prohibition against civil proceedings if it truly is arising under the collective agreement. And in considering your options, it should be a consideration of strategically, where do we want to see this matter go? If you want your day in a hearing to have an adjudicator determine the issue, then you're on the hearing path. If you want to resolve the matter because you think you can resolve it more cheaply and cost effectively, and save everybody a bunch of time, if you settled 3 different competing matters for a small amount to one employee without, prejudice to future settlements or future conduct of the employer, then you should be strategically planning for that path, keeping in mind the different requirements under the legislation. So with that, I am going to turn it over to Victoria, who will be talking about workplace investigations.
Thanks, Eleni. So these topics are don't have a ton of overlap. So if you have questions about what Eleni just spoke about, now's a great time to put those up in the Q&A so we can address those at the end. I'm going to be talking about workplace investigations, and ultimately the fundamental principles of conducting an effective, appropriate workplace investigation don't change that much in the context of a unionized workplace. And so today I'm not going to be discussing, how to conduct a workplace investigation or best practices or what that looks like. We have a really excellent national workplace investigations group, which has been doing webinars on that topic, and will continue to be doing those. But the focus for today is some of the kind of nuances and unique issues that are going to arise when you're doing an investigation in a unionized workplace as opposed to a non-unionized workplace. So, what do I need to be thinking of differently? And what do I need to think of more than I might otherwise? And unfortunately, there's not really anything you need to think about less, but there are some things that are unique that we'll go over. Next slide, please. So in terms of your investigation framework, you're always going to have the employment agreement, your own policies, and applicable legislation apply to your workplace investigation. In the unionized environment, of course, you have the added layer of the collective agreement, which is imposing some additional obligations with respect to both the investigation and then also ultimately at the end of the day, what can you do with the results of your investigation? That's going to be a little bit more limited in the context of a unionized setting. So we won't talk too much about the employment agreement I will highlight just a few things about the applicable legislation and employer policies, but the focus is really going to be on the additional obligations imposed by the collective agreement. And this framework, you want to be thinking of these pieces before you actually start your investigation. So you want to understand what's going to apply in these circumstances. What are my obligations? What needs to happen and within what time frame? So if we can switch to the next slide, please. So this very inscrutable slide with only pictures is just a quick note on employer policies. It's very important to follow your own policies when you're conducting a workplace investigation. And this is important regardless of whether it's related to a union worker or not. But in the unionized context, you can be certain that the union will be going through whatever your policies say you're going to do in the context of investigation with a fine-tooth comb, magnifying glass. The cobwebs here are meant to indicate that your policy should not be sitting gathering dust. You want them to be current. You want them to be compliant with the legislation in your particular jurisdiction, which is going to have some requirements about what needs to be included in there. And ultimately, you want them to be a useful tool. And again, those you want to be thinking about before you start your investigation. What are our obligations under our policy? If we can switch to the next slide, please. So again, applicable legislation, of course, you're going to have your occupational health and safety legislation. That's going to impose generally a duty to investigate. And of course, the duty to provide a safe and healthy workplace. And now psychological safety is part of that obligation. Most occupational health and safety legislation is also going to include your definitions around bullying and harassment. So of course, that's going to be an important piece of your investigation. Not on the slide, but if you also have your Human Rights Code or Act, whatever it is in your applicable jurisdiction. And again, that's going to be relevant in terms of any allegations relating to discrimination. Just a quick flag for federally regulated employers. The Canada Labour Code was updated 2021. Those updates were very significant and dealt pretty extensively with dealing with workplace harassment and violence. So new definitions were imposed. It's particularly relevant for investigations because there are some prescribed steps that have to be followed and some specific timeframes set out when responding to a complaint or notification about workplace harassment or violence. And that's fairly unique because most other jurisdictions, you have to conduct an investigation, but how you do that, there's a fair amount of flexibility. So just know that there's some more prescriptive requirements in that setting that you should be aware of. And of course, you're going to have whatever the applicable labor relations legislation is. And there's sort of two pieces I just wanted to highlight about that. So one very important distinction is in the context of a non-unionized environment, you have your investigation, it's completed. And at the end of the day, maybe the findings aren't inclusive, that there's been misconduct or the misconduct doesn't quite rise to the level of bullying and harassment. But at the end of the day, you're very unhappy with what this particular individual has been doing. And ultimately you decide you maybe want to let them go, not enough for cause, but you let them go without cause. In the unionized context, you need to have just and reasonable cause for discipline or dismissal. So there is an additional threshold that has to be met before you can actually action sort of the investigation findings. That's a little bit more limited than you would otherwise have. The other piece is that, of course, there's unfair labor practices provisions. I'll talk more about this a little later, but I just wanted to flag this as something to be aware of more in terms of the optics of your investigation. So, you know, it's a very vocal union steward who the complaint's been made about, and you're right in the middle of some contentious bargaining. Perhaps you need to be careful about whether or not this is going to be leveraged as some sort of targeting against this individual in relation to their participation in the union, as opposed to investigation into a complaint. So that doesn't mean you don't investigative course, just something to be aware of that might not otherwise apply. We can move on to the next slide. So, of course, the most significant area here is going to be, what does your collective agreement say? And again, this key question is one you want to ask at the outset so that you know what your obligations are. And the question is, what are your obligations and timelines in relation to both the actual investigation and also imposing any sort of discipline or undertaking a dismissal at the end of the investigation, if that's what's required. So the next two slides are not an exhaustive list of everything. Obviously, every collective agreement is going to be a bit unique. And these requirements are going to be unique. So this is more issue spotting in terms of some of the things you're going to want to be looking at. So is the employee entitled to advance notice of an investigation meeting? Is the union? Is there a requirement to provide particulars of the allegations in advance to the employee, the union, or both? And when do those need to be provided? And what actually has to be provided? Is it that they get a copy of the actual complaint? Is there an option to sort of provide a summary of the allegations? What's the scope of that? In terms of the employee having a right to union representation and at what stages, generally that's going to be a yes, anytime there's allegations that might lead to discipline. And similarly, in terms of notification of your right to union representation, best practice would be yes, employee should be notified of that right. Maybe less black and white would be whether witnesses are going to have the right to union representation and sort of when they get notified of that right and how. And the right to union representation is very important. There are cases where discipline ultimately was found to be null and void by an arbitrator because the employer had completely failed to let the employee know that he was entitled to union representation. So he didn't have that. And he didn't have that at either the investigative meeting when the employer kind of confronted him with these allegations in the course of their investigation. And that was found to be very problematic by the arbitrator. If we can switch to the next slide. So this, again, some additional questions to think about. What information is going to have to be disclosed to the union and when? I already talked about particulars or perhaps the complaint. After the investigation, does the union get a copy of the investigation report under the collective agreement? And if so, when? And the last few points on this are sort of shifting to the imposing discipline piece. So are there restrictions around what evidence and documents can be used at an arbitration? So, there might be a restriction that prevents you from relying on allegations in an employee's personnel file if those allegations weren't actually brought to the attention of the employee at the time they were put in there. There might also be time limits on imposing discipline. And there might be time limits in terms of how far back you can go with respect to prior discipline under some sort of sunset clause. And of course, when you're looking at the Grievances arbitration, what's going to be disclosed during that process arising from your investigation. And I'll return to this point a little bit more at the end. So if we can switch to the next slide. So these next few slides are just some additional bits and pieces to be thinking of, again, in the unionized context. And a really big one is optics. Now, this always matters for investigations, regardless of whether they're in the unionized setting, but I'd argue that there's a bit of a heightened, there can be heightened tension and perceptions, depending on the relationship between the union and the employer. So it may make sense more often in the unionized context to have an external investigator come in. There's no history or baggage there. They're going to be seen as impartial. Another question around your collective agreement is, does the union get any sort of say in that? I'd say generally no. But to the extent you're appointing somebody to investigate, you want to ensure that they're going to not just be impartial, but look like they're impartial in terms of anyone scrutinizing that. Again, going back to the risk of an unfair labor practice complaint, what else is going on in the workplace at the time? Do you need to be aware of any additional layers here, just based on what's happening in bargaining, who's involved, and so on? And again, the nature of the relationship, is it one where you know that it's going to be very adversarial and everything you do is going to be contested? And again, maybe an external investigator makes sense there, depending on the type of allegation. So in addition to all the normal questions you'd ask about whether you want it done internally or externally, there's just some added layers there to manage the optics, depending on the relationship. The last point on this slide, in terms of acting promptly to investigate allegations and avoiding what I've called allegation accumulation, you don't want to have a situation where you're sort of sitting on a number of concerns that have happened with respect to an employee, but they haven't been brought to the attention of the employee. And documenting misconduct or identifying misconduct is not the same as addressing it. So one of the things that's very important, generally speaking, for discipline and cause, so not really unique to the unionized environment, is that employees kind of deserve some transparency around if there are performance issues or if there's things they're doing that are not acceptable, that those are being brought to their attention as they're happening and as they're being noticed. So you're not compiling a dossier that they're then confronted with because a complaint comes up and suddenly all of these things become more relevant. All right. So, and the acting promptly, is, of course, again, just that you don't want to be sitting on things. And in the unionized context, that there may be timelines that you're running up against if you do that. If we can go to the next slide, please. Thank you. So again, these are some additional considerations as practices. Regardless of what the collective agreement specifically says, if there are allegations that are going to lead to discipline, or there's serious allegations, generally we recommend having a union representative present and certainly making the employee aware of their right to representation, and importantly that is documented. So there's a clear record that the employee was notified, when they were notified, and then if they chose to do that or not, that's also documented. So you can later refer to it if you need to. The last bullet on this slide is just something that comes up fairly often. It's not specific to union representatives in interviews. I've often got lots of questions about having, the support person, that's an overly involved spouse or whoever else might be. But importantly, the role of the union representative is to support the employee. It's not to help answer questions or to participate or obstruct the interview or investigation process. So to the extent you're retaining an external investigator, this might be a good question to ask them. How are you going to handle the union representative or communicating what their role is? Because you want to ensure you have somebody who's going to be competent, pushing back against any sort of inappropriate intervention in terms of the investigation. And similarly, if you're doing it internally, you want to be aware of kind of the limited role of union rep or whoever else is in that interview, so that you're not dealing with somebody, providing these scripted responses to employees or saying you can't ask that, or otherwise taking this sort of representative role beyond being there. If you can move to the next slide, please. So here's a few more things to think about. Providing particulars in advance. This can be a bit of a careful balance. I think it's important to remember that investigations are not, it's not cross-examination, it's fact-finding. So ultimately, the respondent in an investigation is entitled to know the nature of the allegations. Anyways, what becomes the question is kind of the level of detail that you provide. Might be a moot point if you have to provide a copy of the complaint, if that's going to detail the allegations. But if you're in the situation of kind of providing particulars to the respondent, you're going to want to think a bit about the level of detail to include. So, for example, the allegation is, he called me racist slur, sexist slur, or racist slur. You may not need to include the precise racist slur or precise sexist slur in the particulars when those are being provided ahead of time. Although obviously you're going to want to put them to them in the interview and give them the chance to respond specifically to that. You may want to say, you know, the allegation is that you made racist and sexist comments with respect to X. Very fact specific, obviously, but just something to think about. The confidentiality in the union setting, that's just a little bit to flag that it might be broader in terms of the fact that they can discuss things with their union representative. If both the complainant and the respondent in an investigation are union members, you may want to, and this is more up to the union, but perhaps if the relationship's good, you can flag maybe a different union rep's appropriate, so it's not the same person, depending. And this last piece, people often, again, lots of questions around privilege of the investigation report and retaining privilege. And Eleni and I were chatting about this, and you know, ultimately the investigation, the duty to investigate comes from statute, and there's nothing kind of inherently privileged about the investigation report. And having a lawyer do them also does not automatically make them privileged. What is going to be privileged is any legal advice you're getting in terms of recommendations on what to do. So what disciplines appropriate or recommended, what's that going to, you know, how's that going to hold up? If an arbitrator, for example, or what's the union's reaction to that sanction going to be? That's, of course, all going to be privileged. So typically having recommendations made outside of the investigation report itself would be recommended. But the actual investigation report itself may not be. And that's not necessarily a bad thing, because if you do everything properly and you've conducted an investigation, you know, that's very thorough and complete, you're going to be able to rely on the investigation report in terms of supporting the discipline or sanctions that you ultimately imposed. So the other piece, of course, is that if there is a grievance, any of the people in the investigation, the potentially investigator, are going to be witnesses in any event. So that's sort of all going to. If we can move to the next slide. So just a few best practices, but kind of returning full circle to my original comment. The key principles and best practices for workplace investigations are going to be the same in the unionized context. There's just this added layer of scrutiny from the union. There's the added layer of obligations in the collective agreement. So being very familiar with what those are, what timelines are imposed, and I guess what they aren't as well. So knowing the extent of your obligations, that you're not, you know, doing things that you don't need to, or being asked to do things that you don't need to by the union, but that you know what you have agreed to do in the context of your collective agreement. And of course, these are just kind of the really key principles to any workplace investigation is going to be timely. That doesn't mean it's rushed, and that's not just about how quickly the investigation itself proceeds, but again, kind of when it's started, and not sitting on things, that it's fair and it's balanced, and that right from the beginning of sort of setting up your investigation and determining what that's going to look like, you're doing it in accordance with your own policies, with your applicable collective agreement, and with any applicable legislation. And then from a strategic or I guess management side perspective, you do want to have sort of the possible outcomes in mind. And that doesn't mean that there's a prejudgment or predetermination. And returning to what I already made, investigations are about fact finding. So I hate the expression witch hunt, but I've seen it used by decision makers who seem to love it. Like, oh, this was, the whole point was that they're out to get this person. That's not how investigations work. And a proper investigation is going to be, again, fair and balanced. And it's focused on finding out what happened. But ultimately, you want to be able to ensure that the investigation has been conducted in a way that means you're in a position where you can impose appropriate sanctions on the employee, whether that's some form of discipline, whether it's a case where dismissal is appropriate. You want to be able to have the investigation done in a way that that's going to be upheld. So that's why it's important, I think, kind of to do that upfront investment in terms of really looking at your, what has to happen here to be procedurally fair. A bit dramatic to compare it to criminal proceedings, but I'm thinking of, the police officer who does something slightly wrong at the beginning of something, and then the charges are thrown out at the end of the day because of procedural fairness. Not quite that extreme, but that's sort of the lens here, right? Where the better you can have things done right from the outset, the more solid you're going to be able to be when you're actually actioning the outcome of that investigation, whatever it might be. So that we left time for questions, which I'm not sure how many there have been, but we'll turn it back to Russ.
Yeah, thanks, Victoria and Eleni. That was awesome. So we do have some questions, and I had a couple questions myself, but wanted to give people a chance to, first of all, put in any questions they might have. They might have accumulated. So feel free to type them into the Q&A chat button there. I think it's on my screen, it's next to the chat. And as I mentioned before, we're going to be asking everyone to complete a survey just on their experience with the Spotlight series to date, what they'd like to see going forward. It's not particularly judging Victoria and Eleni. You're welcome to do that. I'm sure it would be all stars across the board, but we're more interested in feedback generally about the Spotlight series. So there's a link there in the chat, and we'd love it if you could just click on it now and just get started on it. Either right now or right at the end, just to give us some feedback to help us shape the coming year. So with that, I'll switch to questions. There was one specific question from one participant about what to do when the collective agreement, I think this is Victoria, is silent with respect to the requirement to provide particulars, I guess, to the union or to the employee. So how do we deal with that?
Yeah, that's going to be very fact dependent, but typically, again, the requirement is sort of that the respondent in the investigation is going to have the opportunity to know a little bit about what case they have to meet before you meet with them. So you're not, ambushing them in this interview meeting with all of these allegations. So I would say best practice, absent kind of unique circumstances, would be to do a summary of what the allegations are for the employee, so that they're able to kind of turn their minds and know a little bit more about what the complaint is, other than just there's a complaint about you and we're meeting X. And if you have an external investigator retained, they should be able to assist you with that. But if you're doing it internally, yeah, typically, it's that balancing act of how much detail, but they should know at least enough to be able to turn their minds to response. And I saw Eleni unmuted. I don't know if you have a comment.
I do have, I think generally speaking, there are circumstances where, and then this goes to the second question that I see in the Q&A as well. I think there may be limited circumstances where you don't want to tip someone off as to what is occurring. But I would think, in a circumstance like that I had an investigation once where the client just wanted to confront the employee about basically theft, misappropriation of funds type issue. And, they thought about it. I advised that maybe you do need to give a heads up. They said, no, he'll start deleting things. It'll be horrible. And I said, okay, fine. And it was one of those circumstances where it was maybe in that less than 1% category where you wouldn't provide, where you would ambush the person, so to speak, to try to get that honest, forthright kind of admission, or you had that person so dead to rights on the misconduct that you were planning to, dismiss for cause in that particular interview as well. So it's a very unique circumstances, I think, where you would not provide that kind of information. In the unionized context, especially, I think that if you're preparing for an ultimate grievance arbitration, how do you best position yourself as the employer to look fair and reasonable, and that everything that occurred was above board and in line with best practices, to make it even more convincing for the arbitrator that the discipline that was chosen was correct. So I think that it's like less than 1% of the time that you wouldn't provide some summary information about what the interview is going to be about and what's being investigated.
It's an interesting question, Eleni. It kind of goes into the multiple proceedings, but what's your advice when you've got a clear discipline case associated with a potential harassment complaint, right? So maybe you've got an incident of workplace violence or workplace harassment that's clear cut, manager witnessed it, they just issue discipline, but there's also a harassment complaint. Is there like order of proceedings? Are proceedings usually combined?
Yeah, I mean, it's tricky because you can't kind of force the proceedings to be combined, because it might be that the victim of the harassment has brought their own type of complaint before workers' compensation or a human rights matter, and they've gone rogue from perhaps the union even, and don't necessarily want the grievance, or the union might choose not to grieve it because they're happy with what the employer did, and they don't have to grieve everything, although they usually do. But I think that you have to really make a plan for how do you best leverage the fact that these proceedings are commenced. So in a lot of different circumstances, you can learn a lot that, the employee that was harassed is no longer talking to you. They now don't trust the employer, they don't trust the union, they don't trust anyone, but they trust the Human Rights Tribunal, or they trust the Workers' Compensation Board. So, those forums will have like a mediation, and the employee will say a lot of things during those mediations. So you can learn a lot about what the matter's really about beyond what was presumed during the investigation or what was found as a matter of course in the normal course of business. And that can really lead to some kind of resolution. So I think that before we start down a path of deferring the proceeding or staying the proceeding or trying to get the proceeding bounced, having that kind of mediation could be a powerful tool, because they just exist. You get a letter saying, do you want to be in mediation? And if you say yes, you can learn a lot about the matter and try to resolve it with the employee in that manner. Sometimes people pull their complaints after they've had that kind of open discussion in a forum that they do trust. So it's important to sort of think about, okay, before we take action, are we considering all the angles here? What's of best benefit to the business?
Right. So another question here: how do employers handle investigations concerning criminal action that has taken place in the workplace, specifically managing the employer's obligation to investigate when a criminal investigation has commenced? So it's another example of multiple sort of streams of obligation.
Yeah, I mean, I'm guessing Eleni will have some thoughts on this as well, but my thought would be, I mean, that you can have parallel proceedings, right? So I don't think you're off the hook to investigate just because there's a criminal investigation going on, because the threshold and standards for that are going to be kind of completely different to what your obligations are as the employer. And then in that case, I mean, that sounds like allegations that are going to be serious enough that you're going to be looking at kind of taking immediate steps to secure the safety of the workplace anyways, and then conducting an investigation. So any other considerations?
Yeah, I mean, I think at the end of the day, you have a statutory duty in most cases, or a duty arising under your collective agreement to undertake this investigation. But you can only do the best you can do. So one of my first investigations, and I was in way over my head, actually, was an investigation. This is many, many years ago, there was an allegation by one of the employees of sexual assault by a different employee at a workplace like event where 20 employees were staying in the same hotel. So guess what? Neither the accused or the complainant wanted to talk to me. So they were talking to the police. So I couldn't talk to them. So the investigation really shifted into, what do we do to prevent these types of issues from happening when we send everybody off to a workplace function or a sales conference or whatever it is. So it turned in, the investigation had to shift, not from disciplining the accused or validating what the victim had to say, but where did things fall apart at this event? And we interviewed everybody else, and they gave a lot of information, about the drinking and about the people having keys to each other's rooms and a lot of things that were not okay and not in line with health and safety obligations. And we tried to rectify it that way. Did we ever have to a grievance resulting from these two people and their interactions? No, because, they were off in the criminal courts. Both of them quit. It was a disaster. But at the end of the day, you can just do the best you can do. And it's important for your investigators, especially if they're internal investigators, to be able to, adjust and move past what might even be said in the collective agreement about the conduct of investigation. So that might involve liaising with the union and being transparent about the fact that, we're facing obstructions in our ability to investigate this matter. People won't talk to us. This is what we're planning to do as a result of these issues involved with the very delicate issue of a criminal investigation by the police layered on top of our workplace issue. So honestly, you just got to do the best you can do at the end of the day.
Awesome. I think we have time for one more question. I guess I don't think there are any more from the participants. I've got one. So, Victoria, you had mentioned the investigation report is not necessarily privileged, and I think that's an issue that we face from time to time. So, what does that mean though practically? If the union just asks for the investigation report, are we going to hand it over? Do we keep it confidential as long as we can? What's the advice on that?
Yeah, that's a great question. And this is something, Eleni and I were chatting about because it comes up as a practical issue quite often, I think, in terms of when do you disclose it? Do you disclose it? I mean, again, there might be a requirement to do so, but to the extent you're pretty confident that the investigation was done well, and I guess there aren't any issues in terms of, because not all investigation reports are created equal. So I suppose it depends a little bit as well in terms of, how much detail is there in the report? Is there a summary of findings that's more appropriate to disclose, that's kind of going to achieve the same purpose? But Eleni, I don't know if we have any more general.
Yeah, I think generally speaking, I like to advise clients and I also like to draft investigation reports in a manner that if it's ordered disclosed, it's still not containing, personal information of employees. If we can, identify them in a way that doesn't disclose their identities, it's, we have to always be concerned that this document might become a public document to some degree in the context of a proceeding. So how do we make it look the best it can look if it is disclosed? But in first instance, we would say you're not entitled to this investigation report, but here's a summary of our findings that grounds our discipline. And then if there's a big fight, remembering at the end of the day that unlike certain investigations in the non-union context where you can keep them a secret forever, you're going to face a arbitration or a proceeding of some sort. And the only way that you can defend your decision-making is with the investigation report, conceivably, or the investigator testifying about the findings and what happened. So at the end of the day, I think from the beginning, you have to think, okay, how do we best position ourselves for a possible proceeding and make sure that this investigation report only helps us with the truth. I'm not saying like to lie, but just how do we make it look as well positioned as possible, which would include not having, opinions with a lot of adjectives about how terrible a particular person is, like something that is professional and neutral and make sure that it's fact-based, anonymizing identities when necessary to protect personal information under privacy laws, those types of considerations. But at the end of the day, there should be a presumption that we may need to use this investigation report. And I just find sometimes when people are thinking about, oh, well, it's privileged, then they let their guard down and they don't act as professionally in some of those documents.
Great. All right. I think we're out of time. That was awesome. Thank you very much, Victoria and Eleni. So once again, we shared the survey. Really ask you to click on that link and go in and give us any feedback you have about particularly how it's been going, what you want to see in the future. Our plans for September, which is our next webinar, is going to be on practical bargaining, collective bargaining tips and tricks, basically. Some advice from a panel on how to approach bargaining, what are some methods that work to get good deals. And we'll also have another update on bargaining trends in terms of wages and strikes in September. So hope you join us for that one. And once again, feel free to always visit the website for links to the recordings and all the articles that we're putting up there as well, the related articles. And yeah, thanks for joining us.